Good morning. For news today,
A loan worth 50,000 ringgit was given by Yayasan Usahawan Niaga to A&A Sdn Berhad, of which the repayment must be met within 3 years. However, until today, A&A Sdn Berhad did not make any repayment to Yayasan. Yayasan would like to sue Atika and Arifah for the repayment of the loan.
Hey, how are you guys doing? Okay, let me just get straight into the point. The reason why I called you guys is because have you guys heard about our company issue with Yayasan Usahawan Niaga? It is regarding the repayment of debt that we have agreed to pay them after 3 years, but we still haven't paid them until today. I would like to ask my lawyer friends here, can I and Arifah being sued when we are just a member and shareholder of the company?
Okay, so for this situation, we can relate with a few section under Company Acts 2016, which is Section 2, a company incorporated under this act or under any corresponding written law. Under Section 25, subsection 1b, the name of a company should end with the following. For example, for private company, it should end with Sdn Berhad.
Plus, the A&A company is a private company because its name ends with Sdn Berhad.
Under Section 20, a company incorporated is a body corporate and have legal personality separate from its member. Section 21, a company should be capable of exercising all the function of a body corporate and have full capacity to carry on business, including to sue and be sued.
Okay, now the next case will be Force and Harbottle. So this case is about two shareholders of the company sued the directors because of the misappropriation of company's property. The court rejected the application on the ground that the shareholders were not a proper plaintiff as they did not have local standing to bring the case. The injury was caused to the company, not to the shareholders personally. Therefore, the company should take an action as it is the proper plaintiff. The company is a proper plaintiff for any cases or liabilities that related to the company. The company's decision to sue in court will be represented by the board of directors or any officer authorized by the company to do so.
I will talk about the effect of incorporation, which is we will refer under section 20 and 21. Once the company enter into incorporation, the company will become a corporate body. Like AA company is a corporate body. AA company had entered into a deal to make repayment of the debt in 3 years. So actually this transaction did not involve any liability of their members, since the company is a corporate body, has the separate entity. So the second effect of incorporation is the company can sue and be sued by the other parties. So once the AA company enter into incorporation, the company should be responsible for any act taken under the company's name. Any transaction will bind the company. So the third party, which is Yayasan, should not sue the members of the company, but Yayasan still can sue the company because not pay the debt in 3 years, right?
Okay, under Section 192, subsection 1, separate legal entity, a member should not be liable for an obligation of a company by reason only of being a member of a company.
Okay, now case is reapplication by Yi Yu. So Yi is a secretary of a company that wholly owned subsidiary of an American corporation. So this case is about the directors of the company left to the Singapore when the company involved with the dispute retrenchment benefits on the workers. So the retrenchment was referred to the industrial court, but during the hearing, no company representative turned out. As a result, the court made an award in the workers' interest. So when the directors left, Yi appointed to be the directors of the company in order to comply the statutory requirement. Okay, guys. But the thing is, the industrial court awards was not being paid. Yi was the one that responsible to pay for the sum. However, the High Court quashed the order. He stated that there was an error in law. A member of a company should not be the one that personally liable to pay for any company's debt or obligation, since the workers work for the company. It should be the company the one that pay for the award. Even though there are some directors, the one that manage the company, but still he does not incur any personal liable when the company commits a breach.
I think Ashika is right. We also can apply section 192 subsection 1, which is Atika and Arifah as different entity from their company. Therefore, AA company has a limited liability and the liability should be charged on the company, not on the personal liable. Actually, the creditor, which is yayasan, should not allowed to sue the members of the company, but the yayasan can sue the company for not pay the debt even the company do not have as left asset in the company.
Oh, I see. Meaning that there's a breach of law between our company with Yayasan Usahawan Niaga. But we shouldn't be liable for it, right? As you just justified just now. Because we're just members and shareholder of the company. So it is a separate entity between us, ourselves, and the company itself. Okay, I think I got it now.
Atika has issued a check to Jannah worth 5,000 ringgit on behalf of the company without stating the name of the company on the check.
Okay, nice. Okay, I have a second issue.
What, Atika? Do you still have a problem? Okay, let me know what.
Okay, the second issue is I have issued a check amounted Rm 5,000 on behalf of the company, but I have not mentioned it. So would the liability would be charged as personal liability on me, or would it still be a company liability?
We can relate with section 21. A company should be capable of exercising all the function of a body corporate and have full capacity to carry on business, including to sue and be sued.
Okay, now case Foss and Harbotter. So this case is about two shareholders sued the directors of the company because of the misappropriation of company's property. The court rejected the application on the ground that the shareholders were not a proper plaintiff as they did not have local standby to bring the case. The injury was caused to the company, not to the shareholders personally. Therefore, the company should take an action as it is the proper plaintiff. The company is a proper plaintiff for any cases or liabilities that related to the company. The company's decision to sue in court will be represented by the board of directors or any officer authorized by the company to do so.
Okay, so under section 21 subsection 1, the AA company has unlimited capacity, includes the ability to sue and be sued on their own name. So if the members of the company, which is you, Atika, make a wrongful act or breach of your duties, so the AA company has a right to take action against you, Atika.
Last but not least, lifting the veil. The court will lift the corporate veil to encompass certain exceptions aimed at providing justice whenever necessary. Here is the situation using company as principal and member as agent and liability in tort. To illustrate, we can look at Aspatra Sendia Berhad and Bank Bumiputra Malaysia cases. The court decided to lift the corporate veil in order to determine whether the company asset actually belonged to the company or that there was an abuse of the doctrine. The finding by the court indicated that the company was really alter ego of Lorraine and thus its assets were essentially Lorraine's assets.
This time, the courts assume that the members or shareholders as the same person as the company. So NA Sendirian Berhad should lift the veil if the members' action was wrong and quite hideous. Therefore, there was a real situation will be revealed in order to ensure whether there was any wrongdoings made or not. If the members found guilty, she should be liable too. There was an exception to the doctrine of separate legal entity.
But actually, AA company will act as a principal and Atika will act as an agent. So basically, if the agent make a mistake, so principal will take a responsibility for the act. But Atika must deal in the ordinary of the business and does not have the bad intention towards the company. If otherwise, Atika, you will be sued personal. It is because the court will leave the corporate will to determine whether the liability is on the company or the liability is on personal liable. Okay?
In this situation, tort may result because of Atika's negligence act toward her own duty, which is not stating the name of the A&A company on the check. The victim of harm, which is Jannah, can file a lawsuit as for the negligence made if it met the other conditions as well. Therefore, the victim must be reimbursed. Thus, the A&A company must be liable with Atika for the mistake.
So meaning that, to conclude, the company may be liable on the agreement made by me, since the company is the principal and would be responsible for any action taken by the agent, as long it was made in the ordinary course of business and done in good faith. Otherwise, I would be personally liable on the agreement made if I made those agreements with some bad intentions towards the company. And other than that, if I made the agreement negligently, it will resulting in liability in torts and will make me and the company vicariously liable on the agreement made.